Is it illegal to place a bet on yourself?
So the kind of the short answer is it all depends. The classic lawyer answer, it all depends. Generally, if you're going to place a bet on yourself in all circumstances, probably okay. If you think you're going to win every game and you want to go ahead and do your best out there, as far as what we're talking about applies. Does the league apply? Does the state prevailing law apply? That's the question to really ask. So can a person place a bet on themselves? Generally not a problem. Now, the secondary issue occurs on, are they going to affect the bet? If their league out there says there's no problem placing bets, for example, in India, cricket has said we're okay with there being bets on our matches. We'd rather have bets on our matches through a legal process than have it be subverted with this unlawful bookmaking with kind of shady bookies than a more legal system. So in the case of in cricket in India, absolutely go ahead, go for it. Place a bet on every one of the matches you're in, not a problem. So that's not a problem by default. Now, if you influence those games, point shaving, match fixing, now we have other issues with probably the league at issue as opposed to a prevailing law in the state or municipality.
If a person places bets on themselves and then they know that nobody else is going to do it, right? But they know they're going to do it, is that legal?
I think not, and again, you have to look at under what standard, under what prevailing means. So, looking at the lens here under this gentleman with his streak under the streaking event under his bet and under his means, he talked about placing a bet under a certain website that does sports bets. And when you look at that website, there's a terms of service under that website's use agreement. So when he clicked on his account to create an account and use that website for his sports betting, he agreed to these terms. And these terms have certain fairness to competition standards in there, and certain fraud prohibitions and criminal prohibitions that are pretty liberal in favor of the betting website. And they have recapture provisions and provisions that say that you lose your winnings in the event that there's any kind of criminal enterprise or any kind of unfair, unsporting issue there. So how he placed his bet and what the mechanism was under his bet, because he used a sports betting website that had terms of service under it, that's where I think he might lose his winnings because it came to him under a terms of service in this agreement under the website.
The Interstate Wire Act of 1961. Talk to me a little bit about that, because I feel like with this particular story, it's important to connect those dots.
Sure. So at the outset, there was a prohibition against, gambling, period, in the country, in the U.S. And there was a carve out for Vegas and later Atlantic City. So that was the law that said, no go and except in those areas. And the idea was they didn't want to allow there to be the use of telephone or wire to gamble if you're not in those locales. So the idea you couldn't use a phone, you couldn't use a computer, any other means to place a bet.
So if I was in New York, right, and there was an event going on over in, Texas, and I called the bookie in Texas, I was like, hey, place $100 on this. Is that what we're talking about here?
Sure, that would be triggered, and that would be a violation. That would be an unlawful bet because, well, say that you're making a bet in New York where it would be unlawful to bet, and then also in Texas where it would be unlawful to bet. But using that means of wire for conveying the bet would be a problem. But say that you made a call to Vegas, to somewhere in Las Vegas, where it's legal to bet in Vegas at that point in time, you're using the phone to place that call, would have been an unlawful event. That call would have been the unlawful issue because you used a wire for that. The big issue really was 2018, where you had the Supreme Court come down and say, "Look, we have carve-outs for certain states. That's somewhat unfair. We're supposed to treat states all equally." So in that New Jersey case where the NCAA was a party, the Supreme Court said, "Wait a second, that's not really fair. We're going to abolish that underlying prohibition against sports betting." and we're going to allow states to do their own things. If states want to go ahead and have their own statutes and their own laws for sports betting, we're going to allow states to do their own thing. And so at that point, 2018, that decision came down from the Supreme Court. They allowed states to codify their own laws regarding betting on sports events and sports books and sports betting. So at that point, many states then codified their own laws. Florida, not being a state which has sports betting statutes on the books, there have been attempts to begin that process, but none have become codified with the legislature. We do have a statute 849, which talks about gambling and goes through a number of issues. And of course, we have scenarios where there is going to be a permission to certain kind of gambling. And up until this past year, we had dog tracks, you have highlight in certain places, pari-mutuel gambling, wagering, the lottery is a form of gambling, obviously. So there are permissible forms of gambling that are carved out in that statute. But then also in that statute, we have areas where we have impermissible forms of gambling. And in that statute, we have 849.26, which talks about certain statutes that prohibit contracts that would allow for there to be gambling. So in this case, here we would have, he might argue that he had a contract. I'm putting down money to bet on a sports book for this side bet. And if he didn't get paid that side book, he might say that he had some contractual relationship with the online website, and therefore he'd want his money based upon this violation of not paying his bet. The law in Florida says, no, sorry, that would be an unenforceable contract, because here in Florida, sports betting is an unlawful enterprise, and that's not something that's permissible to do. So because gambling is unlawful, there is no contract that can be enforced. It's a void action in Florida, and we're not going to have the law enforce that right, because it's not a valid exercise of right in Florida. So the next statute in line would be one where persons against whom suits can be brought to recover on gambling contracts. So say there might be a scenario where someone was maybe defrauded into tendering money for this for a bet or the like, and you could have a scenario where you might be able to bring suit against a person to recover those funds that were brought under pretense of a gambling contract. So someone is a victim, an unwitting victim of believing that there's a sports book possibility in Florida, and they've tendered funds for this bet, even though they might not know it's rightful or legitimate. And so there might be a possibility to go ahead and recover those funds. Also, he might be someone who could be sued in Florida because of his criminal enterprise. And, again, it was a trespass onto the field. It wasn't really a felony. It was a misdemeanor. Breaching the field gates to get on the field to fulfill that bet or make that bet happen. So you might have a scenario where an action can be brought against him in connection with this bet, this gambling scenario. So when you look at the cases under the cheating statute, they really don't line up with what he would have done. For example, you look at like acts and they're more in terms of a fraud enterprise and selling somebody a car fraudulently, or committing a fraud in terms of a monetary transaction. They really line up in terms of a little bit more dubious type acts against people, as opposed to what happened here. So, you might have a state attorney elect to use a statute, the cheating statute, but when you look at what courts are seeing under the statute, the facts aren't really close to this. And I think that maybe his conduct is a little short of what that cheating statute contemplates when you look at what the courts are seeing. So I'm not so sure that cheating statute would be one where you would have a state attorney charge on this and bring an action against, a charging instrument against him and bring it against him.
Okay. Does the Super Bowl streaker have criminal liability for betting than streaking?
I don't think he's going to have criminal liability for the act of placing the bet and then streaking thereafter. That would be certainly a matter of civil liability, but I don't think that's going to be the case. It appears that he placed the bet not within Florida. It's a website. There really not a lot of facts right now to see that he placed it in Florida. If he did place it in Florida, that might change the facts a little bit. But again, the statutes in Florida don't permit sports betting. You can have that twist a little bit. So I don't think so. I don't think you're going to have criminal liability result from him placing the bet and then the streak as a result.
Got it.
He had liability from the trespass, but probably not that combination.